Okay, on the record, in the matter of LG Park LLC versus Stephanie Miller, file number 23-02954. Is Stephanie Miller in the courtroom? Yes. Okay, you can come up to the table. Counsel appearance.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff.
Okay, and you're Stephanie Miller?
Yes, ma'am.
Okay, Ms. Miller, today was the date and the time that was set for a hearing for non-payment of rent. I have a consent order for conditional dismissal. It states that you all have come to a resolution whereby the case will be dismissed today and that you agree that you will pay the following to plaintiff: rent owed in the amount of $1,145 plus court costs, $221.02, for a total of $1,366.02, and that you'll make that payment. It says payment defendant shall pay by February and March rent $955 on the first of the month. Defendant shall pay $705 by February 29th. Is that what that says?
Correct.
2024, and the balance of this judgment no later than March 30th, 2024. Is that your understanding of how you're going to proceed?
Yes, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Thank you. And you understand, ma'am, that this matter will have the case dismissed today, but that you have to perform completely as it's stated and indicated here in section 3.
Yes, ma'am.
So partial performance will not satisfy that. You understand that?
Yes, ma'am.
And that if you don't perform fully, that the plaintiff can seek an immediate writ against you and judgment will enter against you. You understand that?
Yes, ma'am.
You have the right to be represented by an attorney today. You were advised of that right at the time of your pretrial. You've appeared without an attorney. Are you waiving your right to be represented by attorney today?
I wasn't appointed. They said I wasn't eligible.
I understand that. You wouldn't get appointed an attorney anyways because you don't have a right to court-appointed counsel in a civil matter or landlord-tenant matter, which is a civil matter. But you did have the right to hire an attorney if you would like.
No.
But you've not hired an attorney. So in order for you to move forward with a resolution, others are going to waive that right so that you can enter into this conditional dismissal.
Yes, ma'am.
You also have the right to have a trial. You have the right to have a jury trial. Did you want to waive your right to trial in order to move forward with the consent order for conditional dismissal?
Yes, Your
Anybody making any promises to you or threatening you to get you to waive those rights?
No.
Okay, you have 3 business days from today's date. Once you leave here, you realize you misunderstood the rights that you waived, you can return to the court within those 3 business days. You can request to have this set aside. We'll set it for a hearing, okay?
Okay.
And then you'll have to explain to the court how it was that you misunderstood your rights. Lastly, your signature is here on the bottom, is that correct?
Yes, ma'am.
We'll get you a copy of this conditional dismissal and you'll be on your way unless you have questions for the court.
No, I don't.
Okay, any additional matters for the record, counsel?
Nothing for plaintiff, Your Honor. Thank you.
Thank you, you're all set.
Thank you.
You're welcome. On the record, in the matter of Todd Dowrick versus Jacob Castelline and Misty Whitaker, file number is 23-02917. Appearance for the record, counsel?
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff.
Okay, what's your name, sir?
Jacob Castelline.
And what's your name, ma'am? Okay, today was the date and the time that was set for hearing for non-payment of rent. I have here a consent order for conditional dismissal. It says that you all want to enter into an agreement whereby you agree that the case will be dismissed today and that you will pay on or before January 22nd, 2024, the amount of rent, $370 plus court costs of $75 for a grand total of $455. and that will be due through the time period ending of January 31st, 2024. Does that sound accurate?
Yes, ma'am.
Okay, and that it says payment is already in the mail of $300 will be certified once it clears. That's complete and accurate as well?
Yes.
Okay, and that's how you want to resolve this today. Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes.
Thank you. You have the right in this matter to proceed to a trial, and you have the right to jury trial. You were advised of that right during your pre-trial back on December 6th. Are you willing to give up your right to a trial so that you can move forward with the conditional dismissal?
Yes.
You also have the right to be represented by an attorney, and you've not appeared with an attorney today. Are you waiving your right to counsel today?
Yes.
Oh, anybody threatening you to get you to waive any of those rights?
No, ma'am.
Any promises being made to you to get you to waive your rights?
No, ma'am.
You understand that partial performance will not satisfy this, so you have to perform completely as it states here on this document. Otherwise, the plaintiff can request judgment to enter against you, and writ will enter against you immediately as well. You understand that? And I have 2 signatures on the bottom, and those are your signatures there.
Yes, ma'am.
Do you have any questions for the court?
No.
You have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights that you've waived in order to enter into this conditional dismissal, you would return to the court, request to set this agreement aside, and we'll set it for a hearing, okay?
Yes, ma'am.
I'm gonna get you a copy of the conditional dismissal in just a moment. Any additional matters for the record?
Nothing for plaintiff, Your Honor, thank you.
Any questions from you all? Okay, you're all set, thank you. On the record, in the matter of Aspar LLC versus Richard Williams and Beverly Williams, phone number is 23-02920.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
What's your name, ma'am?
Beverly Williams.
Okay, what's your name, sir?
Richard Williams.
Okay, today's the date and the time that was set for hearing for non-payment of rent. My understanding is that the parties could not come to resolution, is that correct?
That's correct, Your Honor.
Okay, and the tenants believe you have a lawful reason whereby you withheld the rent?
Yes.
Okay, and so we need to have a hearing?
I think that's the case, Your Honor.
Okay, well, I'm gonna reset it because it's already 3 o'clock, and Mr. Whitty, you've got some more 2 o'clocks and some 2:30s and some 2:45s.
Busy day, Your Honor, I know.
January 31st at 2:45. January 31st at 2:45 will be your next court date, okay? Be prepared to present your evidence at that time. Yes.
Last time we was here, you all asked us if we needed an attorney. We said yes. And then they said that he or she will be here today, but we haven't seen him.
So you met with legal services, is what you're saying?
This guy here.
No, you met with legal services last time?
Yes.
Okay, and they did not take your case, is that what you're saying? Or they told you they were taking your
They
case?
told us that we would take our case and then the attorney here and we get here.
Okay, we've not received an appearance on your behalf, but you have a seat back here. I do have Ms. Carrera back here. She can confirm if your case was taken or not, okay?
So what do we do?
You just have a seat right there. If legal services did not take your case, then you can hire your own attorney. You can contact the state bar also to see if there's any other resources that could assist you. But this is a landlord-tenant civil matter, so you don't have the right to court-appointed counsel here, okay?
Oh, I didn't know that.
Okay, yeah, so you have a seat back there. We'll get someone from legal services to confirm if you were supposed to be represented by their office, okay?
Okay, and whatever else, what else did you say before?
If they're not able to represent you, then you would have to hire your own attorney, or you can contact the state bar to see if there's any other resources or law clinics that could assist you, okay?
Okay, we said a court date.
I'm gonna get you the court date for your next court date right now. That's January 31st. Okay, on the record, in the matter of the Grove versus Lakia Leak and London Leak, file number 23-0292, LT, counsel appearance.
Good afternoon, Your Honor. I'm Woody appearing on behalf of the plaintiff.
Okay, is London Leak or Lakia Leak present?
I am. Can you hear me? Hello? Hello?
I hear you. What is your name?
Lakia. I'm not sure why they got my 8-year-old daughter on there, but I'm Lakia Lee.
Your daughter on. I'm not sure either. I'm also not sure why you're via Zoom when my order to appear said in person.
Okay, I'm all over the place. I was in your courtroom at 8 o'clock this morning on Zoom, and they told me to come back at 2 o'clock. So I'm not sure.
I'm
I don't
not
want
sure either. Please start your video. Okay, so I'm assuming you did not meet with Mr. Whitty yet?
No.
Okay, you hang tight. We'll get him in a private meeting room with you when he's available to get on Zoom, okay?
All right.
And you said that London Leak is your 8-year-old child?
Yeah, it should be my name.
I agree, but we'll make sure that that's addressed.
Okay.
Okay, let's see, and then you've not met with the 230s, is that correct?
I haven't yet, Your Honor.
Okay, is Latoya Jones present? Okay, Latoya Jones is in the hallway, and then Ms. Pereira is present on behalf of Parson, is that correct?
Yes, we have a CD.
Okay, we can do that one. On the record, in the matter of LG Park Place versus Dwayne Parson, file number 23-2951, LT counsel appearance.
Good afternoon, Your Honor. I'm Woody appearing on behalf of the plaintiff.
And Veronica Pereira appearing on behalf of Mr. Person.
Okay, and Mr. Parson is present via Zoom. Mr. Parson, you can unmute now. Okay, today was the date, today was the date and the time that was set for a hearing for non-payment of rent. I do have a conditional dismissal in order. That's how the parties are gonna resolve this, is that correct?
That's correct, Your Honor.
Yes, sir.
Okay, it says that this case is dismissed without prejudice, subject to the conditions below. The defendant shall move out the property and surrender possession entirely on or before January 31st, 2024. Defendant shall notify plaintiff upon moving out and return the keys to the plaintiff on or before January 31st, 2024. Should the defendant default on the terms of this agreement, the action may proceed without notice to the defendant, and the action will be reinstated upon plaintiff submitted an affidavit of default. An order of reinstatement of the case may be affixed to the affidavit, and a judgment for possession in order for eviction, which shall enter simultaneously. Is that how you understand your matter to be proceeding, Mr. Parson?
Correct.
Please raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, you can put your hand down. Okay, and in this particular case, you were represented by counsel, but you also have the right to proceed to a trial, and you have the right to jury trial. Did you want to waive your jury trial today in order to have this matter resolved by conditional dismissal?
I do.
Anybody threatening you to get you to waive that right?
No, ma'am.
Okay, and I do see where there was a signature affixed to the agreement here. I see Mr. Woody's signature and yours, Ms. Pereira.
Yes.
Okay, Mr. Carson, did you have any questions about the court regarding how this is being resolved?
No.
You understand partial performance will not satisfy this, so you must move out and surrender your keys. And that means that you're taking all of your possessions out no later than the 31st of this month. You understand that?
I do.
Okay. Okay, we'll sign the agreement. Any additional matters for the record today?
Nothing to plaintiff, Your Honor.
No, thank you, Your Honor.
Okay, Mr. Parson, you're all set.
Thank you.
You're welcome. Let's see. Ms. Ferrer, you also representing Porter
Yes, Your Honor.
on the record in the matter of LG Lansing versus and Superior Management versus Michaela Porter, file number 23-02977 LT, counsel appearance.
Good afternoon, Your Honor. Hugh Woodrow, P56468, appearing on behalf of the plaintiff.
And Veronica Pereira appearing on behalf of Ms. Porter.
Okay, Ms. Porter is present via Zoom. Today was
Yes,
the
ma'am.
date. Thank you. Today was the date and the time Ms. Porter set for a hearing for non-payment of rent. I do have a consent order and conditional dismissal here. It states, Ms. Porter, that you are agreeing to have the case dismissed today without prejudice upon the condition that you'll pay the past due rent in the amount of $4,099 plus court costs, $156 for a total of $4,255 due. That includes rent due to the time ending of January 31st, 2024. It states that you will make payments on the arrears as follows. You're gonna pay $936 by January 20th, $710 by February 20th, $710 by March 20th, $720 by April 20th, $710 by May 20th, and then $479 by June 20th. In addition,
I'm sorry, you said what?
I'm sorry, I have to find out who's coughing without being on mute so I can mute them.
Oh, okay.
Okay, it says, in addition, you will maintain your monthly rent payments of $936 on or before the 5th of each month until the arrears are satisfied on or before June 20th, 2024. Does that sound like a complete and accurate understanding of what you negotiated as a resolution on this?
Yes, ma'am.
Raise your right hand, please. You solemnly swear, is that the right hand? I don't know how your screen is. Are you, thank you.
Sorry. My other right.
Yes, thank you. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, ma'am.
Okay, you understand, ma'am, that you did have the right in this matter to proceed to a jury trial?
Yes, ma'am.
Okay, and are you willing to give up your jury trial in order to enter into a conditional dismissal?
Yes, ma'am.
Okay, you did have the right to be represented by counsel. You are represented by an attorney in this matter. And so I do have a signed copy of the consent order for conditional dismissal, and you did sign or give your attorney, it looks like this is your signature though. You did sign this document, that's correct?
Yes, ma'am.
Okay, and I see Ms. Pereira's signature as well as yours, Mr. Woodrow. Do you have any questions, Ms. Porter, about this conditional dismissal?
No, ma'am. I just wanted to let the court know that I am seeking assistance with my job as well, because we have a care fund. I work at Wendy's. So I'm in the process of seeing if they can help as well. Get this balance
Very
out.
good. Okay, very good. Hopefully that works out for you. You understand that partial performance will not satisfy this. So you made an agreement that on certain dates, you're gonna pay a certain amount. So that means you have to follow this agreement to the T. You can't decide that you're gonna pay the amounts that you're supposed to pay on January 20th on another date later than that. You also can't decide that although you're supposed to pay, let's say $936 on January 20th, that you can pay $935. Because once you do that, although it may seem minor to you, you breach the agreement and they can request to have a judgment entered against you and have a writ of eviction issued simultaneously. You understand that?
Yes, ma'am.
Okay. And so any other negotiations as it relates to your job providing assistance, you'll work directly with your landlord or your leasing office in order to let them know what's going on in that regard.
Got your back. Thank you.
You're welcome. Other than that, I'm going to sign and date that for today. We'll make sure your attorney gets a copy, okay?
Yes, ma'am.
Any additional matters for the record, counsel?
No, Your Honor.
No, Your Honor, thank you.
You're all set. Thank you.
Thank you.
No problem.
Am I good to go?
You are good to go. Thank you.
Thank you. You guys have a great day.
Same to you.
Thank you.
Mr. Akanicki is here. Is Taronda Whitehorn present? That's you, ma'am? You come up to the table there. I'm sorry? You can have a seat if you like. Okay, we're on the record in the matter of TK Rentals LLC versus Taronda Whitehorn and all other occupants. File number 23-03114 LT, counsel appearance.
Good afternoon, Your Honor. Robert Akanicki, attorney for the plaintiff.
Okay, and then I have Taronda Whitehorn present in the courtroom. And today was the date that was set for a hearing for non-payment of rent, but I do have a conditional dismissal. It states here that the parties are entering an agreement whereby the case will be dismissed today upon the condition that you, Ms. Whitehorn, will vacate the property on or before February 15, 2024. Is that correct?
It wasn't eviction, it was, they want possession of the property.
Correct, that they're gonna dismiss the case and you're gonna vacate by February 15th?
Yeah, because I have a voucher and then.
That's what they're gonna dismiss the case.
Yeah, okay.
So you're not being evicted. This is an agreement that to avoid eviction, they'll dismiss the case today so long as you vacate
By the 15th.
by the 15th. And that's you and all other occupants.
Yeah, I know.
Okay, you understand that?
I do.
Okay, you understand that vacate means you gotta take all your stuff, you gotta turn over your keys, you gotta do it on or before the 15th. You can't do it on the 16th.
Who do I give it to when I don't even know who TK Reynolds is?
Mr. Akanicki, who should she give her key to?
Ms. Whitehorn, you can communicate with me and I can arrange that to be dropped off at my office.
Okay, so you contact Mr. Akanicki, he's gonna make arrangements for you to get the key to him, okay?
All right.
Okay, and so you'll make sure you get that done, because you want that done before the 15th, because if you don't do it, what could happen is they can seek the eviction immediately without even notifying you, because you entered this agreement. You understand that?
Yes, I do.
Raise your right hand. Your other right hand. Do you solemnly swear or affirm the testimony you're gonna give us the truth and the whole truth under penalty of perjury?
Yes, I do.
Thank you. You can put your hand down. You have the right, ma'am, in this matter to be represented by an attorney. We advised you of that right and additional rights at the time of your pretrial back in December. Are you willing to give up your right to be represented by an attorney to do a conditional dismissal?
Yes, they said they wouldn't represent me on this case.
I recognize that legal services probably would not represent you. They have a capacity anyways, but that doesn't mean that you don't have the right to be represented by an attorney. You have the right to hire your own attorney in this matter. You understand that? Okay, so you want to waive your right to an attorney. You also have the right in this matter to have a trial. You have the right to a jury trial. Did you want to waive your right to trial today?
Yes, please.
Okay, anybody threatening you to get you to waive these rights? Has there been any promises to get you to waive these rights? Do you have any questions about the conditional dismissal?
It won't be on my record.
This case is dismissed. That's what a dismissal is. When we dismiss it, it's dismissed. But this is dismissed with a condition.
That's what I said when you say conditional. So
Yeah,
that means by the 15th is the condition.
That's the condition.
Gotcha.
So long as you comply, this case will never exist again.
Yeah.
If you don't comply, and that could mean that you did leave on the 15th, but you left trash in the property and they got to get it out, or you left your stuff there, or you didn't leave on the 15th, you left on the 16th, or you left and you didn't get your keys to them on the 15th. Any number of those things could be a violation of this dismissal. You know that?
No, I didn't.
Yes, so you have to comply completely. You gotta be out of this property by the 15th with all of your stuff. You gotta leave that property in broom swept condition like you're supposed to whenever you're renting from people, and you gotta turn over that key by the 15th, not the 16th, okay?
Yeah.
You got it now?
Oh, yeah, I got it.
Because if you don't, then all of a sudden you're getting an eviction on your record.
I want my security deposit back, so yes.
That too, okay. And so you have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that we discussed that you waived. You can return to the court, you can request to have this set aside, and then we'll set it for a hearing, okay?
Okay.
Do you have any questions at this time? Okay, and I lastly want to double check to make sure that your signature is here. I don't see your signature.
That's why I'm here today. Thank you. Need it also?
Yes, please. Thank you. Okay, I'll date and sign this for today. We'll get you a copy and then you'll be on your way, okay, ma'am?
Oh, my.
No problem. Any additional matters for the record, counsel?
No, Your Honor, thank you.
Okay, you're all set. You can have a seat back there. We'll get you what you need.
All right.
Okay. Mr. Visconti, which matter are you here for?
Your Honor, I have Mary Avenue, LDHA versus Yvette Ross.
I was just right. You said you're here for the one with Ross. I see an Uthman Ross.
3167.
That's a vet. He says a vet, right? Ross, that one.
Ross, yes.
Yeah, I see Uthman Ross on Zoom. I'm trying to see if that's the same person. Maybe they're not responding.
Yes, ma'am.
Okay, is the vet Ross with you?
We don't know where Miss Yvette Ross is. My son, which he's at Raskin, but he was late going to school because our initial appointment was for 10 o'clock or 10:30 this morning. So he said 2:45 and he has a wrestling meet today. So I'm standing in place for him because he was left behind in this apartment. And we went to the apartment today and talked to the new owners because apparently they sold, the property managers, whoever owned it before, sold it. So we went and talked to the new manager, and she had asked us to ask you guys to give my son information for the new property manager so that he can contact them and see if we can rectify the situation.
Okay. I think we already put here that there should have been a default for Yvette Ross. That's my note from the last court date. And so Uthman Ross is here. Did you meet with him?
I did not, Your Honor.
Okay, are you able to get on Zoom to meet with him?
I can.
Okay, we're gonna get Mr. Visconti, the plaintiff's attorney, in a private meeting room with you to get some clarity on this and see if you all can resolve it.
All right, and Ms. Simmons, my
Yes.
name is Ottman.
Othman?
Ottman, yes, ma'am.
Othman. Okay, and I'm Judge
Yes,
Simmons
ma'am.
when you're in court, okay?
I'll step down.
It's understood, ma'am. Yes, ma'am.
Okay, Mr. Visconti will be on in just a moment.
Yep.
Okay, and then, Ms. Pereira, did you have another one? No.
Omar Thompson, I think, had a chance to speak with Mr. Woody about this one yet. We're in the queue.
Mr. Wood, do you have one ready to go?
We do.
Okay.
Sorry.
On the record, in the matter of Todd Dowick versus Latoya Jones, file number is 23-02916, counsel appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
You're Latoya Jones, ma'am? Okay, Ms. Jones, today was the date and time that was set for a hearing for non-payment of rent. I do have a consent order for conditional dismissal. It says that the parties are entering into an agreement whereby the case will be dismissed today upon the agreement that the defendant will pay to the plaintiff $664.16 for past due rent due and owing for a period through January 31st, 2024, and that you will pay court costs of $197.16 for a total of $861.32. Again, that you will do that on or before January 31st, 2024, or vacate the property by that time. Is that an accurate understanding of how you're going to proceed? Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Okay, this document, I do see a signature. Is that your signature, ma'am? You understand that you have the right to be represented by an attorney today? You want to give up your right to be represented by counsel in order to do a conditional dismissal? Not want to give up your right to be represented by an attorney? Did you hire an attorney, ma'am? Okay, you were advised of your right to be represented by counsel during this eviction proceeding, and you were advised of that at your court date in December. You did not hire an attorney, so you want to give up the right, correct? Okay, very good. And then you also have the right to proceed to a trial. You have the right to a jury trial in this matter. Did you know that? Okay, well, I'm going to advise you, you have the right to have a jury trial in this matter. Did you want to waive jury trial and have a conditional dismissal? Okay, so you're waiving your jury trial? Anybody threatening you to get you to waive those rights? Any promises if you waive those rights? I have to hear you on the record. Okay, you have 3 business days from today. If once you leave here, you decide, you know what, I didn't understand those rights, I didn't mean to waive them, you can return to the court, request to have this set aside, we'll set it for a hearing. You also need to understand that partial performance of this conditional dismissal will not satisfy this agreement. Partial performance means that you didn't do exactly what was going on here. You were agreeing that you're gonna pay $861.32 before or on January 31st of this year, or you'll vacate by that date. You understand that? Do you have any questions about this agreement? We'll get you a copy. Any additional matters for the record?
Nothing further, Your Honor. Thank you.
Thank you. On the record in the matter of Crystal Ragonis versus James David and Samantha Bates. File number is 23-02761. What's your name?
Samantha Bates.
What's your name?
James David.
Okay, today was the date and the time that was set for a hearing for termination of tenancy. For the record, as Samantha Bates, there was already a default entered against you because you were supposed to appear back on November 8th, and you did not appear in court. They did submit a default as to you. They were supposed to appear today for a court date against Mr. David. They were scheduled for, the plaintiff was scheduled for 3 o'clock, it's 3:16. I don't have anybody present on behalf of Crystal Dragonis. So the case will be dismissed, okay?
Thank you very much, Your Honor. And
You're free to go. Thank
thank you
you.
very much, and you have a great day. Now.
Same to you. Okay, on the record, in the matter of Mary Avenue LDHA versus Yvette Ross, council appearance.
Good afternoon, Your Honor. Robert Visconti, P61756 on behalf of the plaintiff.
And that is file number 23-03167 LTE. Yvette Ross was previously defaulted. We do have Ben Ross present. If you can start your video, sir. Okay, the parties met privately. Were you able to come to a resolution?
No, Your Honor, we were not. Mr.
Okay.
Ross indicated that it was his intention to ask for a trial for his son.
Okay.
I guess I'd ask the court for clarification. Was there a default judgment entered against Yvette Ross?
There was a default as to Yvette Ross. Obviously, it's just named Yvette Ross and all other occupants. I'm assuming that there was, that no one appeared. It was service by attachment. Mr. Is the son King? Is that the son's name?
Yes, ma'am.
King Ross appeared at the pre-trial, indicating that he was in the property. I'm not sure I caught that you said Mr. King Ross had something else going on today?
Yeah, he got a wrestling meet. He had already went to school late because we thought we had the earlier court time, but it was changed and I took him to school and he has a wrestling meet. He was chimed in, but now they got to go get ready to do the wrestling.
Okay, my understanding is that Mr. King Ross did zoom in briefly today. Nonetheless, Mr. King wants to demand a jury.
Yes, ma'am. And at the same time, though, let me say this: that was his first decision. That's before we went into the office, because we didn't have any idea that the property that's going up against them now is they sold the property to somebody else. So the people that has the
Do
property.
you reside in this property, sir?
Yes, ma'am.
Okay, so you also reside in there, okay. So it's not just Mr. King, Ross, that wants to demand a trial. You want to demand one as well?
Yes, ma'am. And at the same time, though, I would like the information because the manager told me to ask you guys to give me the information to the new property manager so that we can see if we can resolve the situation.
The manager asked you to ask you guys. Who's you guys? For what information?
For the new property manager, like this, I guess the people that's over the new property management. I ain't never been through this type of stuff, so I don't know the proper terminology on what I'm saying.
I understand that. Okay, well, first of all, the notice to appear for a hearing was in person. So in the future, you need to appear in person. You're gonna need to complete a jury demand. I'll note here in the file that you are requesting a jury demand, okay?
Okay, so I gotta come up there?
You're gonna have to come in person for sure in order to have a jury trial. But we need that jury demand paperwork completed and so you'll probably have to come up to do that unless you know how to e-file it, electronically file it through my file. You need to come up, complete the jury demand, and then you'll pay the fee for a jury unless you are granted a waiver for the jury trial, okay?
Yes, ma'am.
Are you gonna be able to do that this week?
Yes, ma'am.
Which day?
Probably Friday.
Note here that you'll appear by Friday for that purpose to get that paperwork completed. And then you need the contact information for the property management.
Yeah, the new one, not the old one, but the new people.
Who's the current property manager?
Your Honor, I have no idea what Mr. Ross is referring to. He indicates that he went into the office, spoke with somebody who apparently works there, who told him to ask for somebody else's contact information. I don't have anybody else's contact information other than the office at the property.
Okay.
Philip C. Dean. So whoever the original property manager of Philip C. Dean, they sold it to another property management. That's what I'm talking about. Which we knew nothing about.
I don't know either. Your landlord's name as it relates to the demand for possession is Philip C. Dean Apartments. And then I have here on the summons, Mary Avenue LDHA doing business as Philip C. Dean Apartments.
Okay, and the new people name is, let me find this paper.
It's gonna tell you who your client is.
Oh,
Mr. Ross, are you there or are you frozen? Okay, looks like he's frozen. We're off the record. That's all we need for today. They'll come in and file a jury demand.
Do we have a return date? Or are we gonna wait to see if the demand's filed?
Well, if he doesn't file a demand by Friday, then I'll reset it for another hearing in person.
So you had indicated there was a default as to it, Ross. Did we have a judgment that was entered against her?
We never received a default. That was back on December 6th. Okay, Mr. Ross is back. Mr. Ross, did you find the name of the party you were looking for?
What's the name of the original property management you said, LLC?
I have
Because I'm looking.
Mary Avenue, LDHA, doing business as Philip Dean Apartments.
Okay, this paper that I have, it says Premier Property Management LLC. And I guess they're in Fenton, Michigan.
What is the paperwork you're looking at, sir?
One that was on my door. And this
Who's on your
supposed to
door?
be the new, this is supposed to be the new management that took over.
Okay, the court has no information on that, so, and Mr. Visconti doesn't appear to know anything about that either. But you
Right.
bring that, you can bring that with you when you come to court in person, okay?
Yes, ma'am.
Okay, you're all set for today. Don't forget to file, come in to file your jury demand, okay?
Yes, ma'am. Fine. Yes, ma'am. Now, do I
Thank
come
you.
up to Ingham County Courthouse?
We're in City Hall you're gonna go to the 5th floor for this purpose. But the court is on the 6th
Okay.
floor, but you're going to the civil department on the 5th floor.
Okay, ma'am. Thank you, Judge.
You're welcome.
Thank you, Your Honor.
Thank you. Let's see here. Waiting for Mr. Woody, I think. And what's your name, ma'am?
Rita Dunlap for SJ Commercial Properties of the landlord.
Okay. Okay, Mr. Woody, who do you have?
If you give me like 10 seconds here, we'll do the Thompson. That's okay.
Should be in files. Mayor Pro Tem.
Yes. Okay, on the record in the matter of SJ Commercial Properties versus Omar Thompson, file number 23-02957 LT, counsel appearance.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff.
And Veronica for appearing on behalf of the defendant who is present to my right.
How are you, Mr. Thompson?
Good evening. I'm okay.
Okay, very good. Today's date that was set for a hearing for termination of tenancy. I have here a consent order for conditional dismissal. It says, Mr. Thompson, that you are agreeing to have the case dismissed today upon the condition that you will vacate and turn over the keys on or before January 31st, 2024. And the supplemental complaint will be dismissed without prejudice. Is that accurate?
Yes, sir.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
Yes, Your Honor.
You can put your hand down. Okay, you had a couple of rights that you would have to give up in order to move forward with this conditional dismissal. Actually, you only gotta give up one right because you are represented by counsel. The other right is the right to have a jury trial. Did you know you have the right to jury trial?
Yes, Your Honor.
Okay, and you've not, well, you want to enter an era by you have your supplemental complaint dismissed. Are you waiving your right to trial in this matter so that you can move forward with this agreement?
Yes, Your Honor.
Anybody threatening you to get you to move forward in this direction?
No.
Okay, and so you understand that partial performance and partial payment will not satisfy this agreement. You understand that?
Yes.
Okay. You also understand that if you don't vacate the property and turn over the keys by the 31st of this month, the plaintiff can request to have judgment entered against you immediately, and a writ of eviction will also enter immediately against you. You understand that?
Yes.
Do you have any questions about this agreement?
No, Your Honor.
Okay, did you give your attorney permission to sign this for you?
Yes.
Okay. You have 3 business days from today's date. If once you leave here, you realize you misunderstood the right that you waived, which is your right to your trial, you can return to court and have this agreement set aside, and we'll set it for a hearing for you to explain to us how you misunderstood your rights. Any additional matters for the record, counsel?
Nothing for plaintiff, Your Honor. Thank you.
No, thank you, Your Honor.
Thank you. We'll get you a copy in just a moment.
Thank you.
No problem. Did you meet with Ms. Leak already?
I did, Your Honor.
Okay. On the record, in the matter of the Grove versus Lakia Leak, file number 23-02921 LTE, counsel appearance.
Good afternoon, Your Honor. Norman Woody appearing on behalf of the plaintiff.
Please start your video. Okay, today was the date and the time that was set for a hearing. Parties come to a resolution.
Your Honor, unfortunately, we were unable to reach an agreement on this matter. I think that it's a pretty simple case, but we cannot resolve it.
Okay, and Ms. Lee, you believe you have a lawful reason whereby you have withheld your rent and you still maintain possession of the property?
So like the attorney said, this could be so simple. Like we shouldn't even be here. But yes, to answer your question.
You can proceed.
Your Honor, at this time, I'd like to call Kathy Berry as a witness.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? You can have a seat. Okay, state your first and last name, spell both.
Kathy Berry, K-A-T-H-I-B-E-R-R-Y.
You can proceed, Mr. Whitty.
Thank you, Your Honor. Ms. Berry, could you describe your relationship with the Grove?
I'm a property manager.
Are you an on-site property manager?
I am.
Are you familiar with the lease agreement between Lakia Leak and the Grove?
I am.
Under the leases are currently $9,613.82 owing.
I believe so, yes.
Are there also court costs of $189.86?
Correct.
Are you seeking a possession judgment today in the amount of $9,803.68?
Yes.
And to the best of your knowledge, has the premises been kept fit for their use as a residential dwelling?
I believe so, yes.
Now, is it your understanding that Ms. Leak is taking the position that she has been unable to pay due to inability to access the tenant portal?
That is what she stated, yes.
And has the plaintiff taken any action in any way to deny her access to the portal?
Absolutely not.
Have you taken any action to provide her with access to the portal?
I have, and it's on, sent several resets to her emails. And that group of papers I've given you.
Okay, would it be helpful if you reviewed those documents?
Sure.
I only have one copy of this. I would mark it as Exhibit 1, if I may.
Okay.
May I approach?
Yes.
Handing you with the Marcus Exhibit 1. Can you identify that document?
That's a history and notes for Ms. Leaks.
Is that a business record that the Grove keeps in the ordinary course of business?
Yes.
Does the Grove rely on that record in order to maintain its business?
Absolutely.
Is that record reasonably accurate in terms of reporting the interactions between the Grove and the tenant?
Completely accurate.
And are you the custodian of that record?
Yes.
I move for admission of Exhibit 1.
All right, what is the document called again?
Is the transaction history.
Transaction history. Any objection to the transaction history being admitted as an exhibit? Got questions for you, Ms. Leak? Ms. Leak, can you hear me?
I can. So I'm not sure what any of that means, to be honest with you.
Okay, so they want to admit an exhibit. The exhibit is transaction history. And my question was, did you have an objection to that being admitted? Objection meaning you don't want it admitted because you believe it violates a evidentiary rule. And typically, because you were supposed to be here in person, the attorney would have to show you what that record was before he gave it to the witness, but you didn't appear, so he can't show it to you.
Gotcha. Okay, I guess no objections, but it's not going to be a transaction history if I have been able to pay. So I don't. But
So that sounds like a dispute to there being a transaction history, not necessarily an objection to this exhibit being outside of the evidentiary rule. So for that purpose, the exhibit is admitted. And then you'll have an opportunity to give your dispute when we call you for your testimony, okay? You can proceed.
Thank you. Ms. Berry, without going through every line of that document in detail, since it's fairly voluminous, can you briefly summarize what it reflects in terms of the communications between you and Ms. Leak and the issue of her ability to pay through the portal?
Our calls log and we have a texting ability as well. So this is the texting of any incoming or outgoing call, text or email with Ms. Leak. We had some emails back and forth. She was gonna be late, said no problem. When it was the time for her to pay, she did not. I said I was filing court documents. She then immediately kind of shut down and said she was not able to get on the portal.
Did you, I'm sorry, and what did you do in response to her statement that she could not get on the
There's
portal?
a reset so that you can completely reset and it goes to her email.
Did you send her a reset?
I did send her several resets.
How many resets approximately did you send her?
On 7/7, I told her it looks like you were locked out of the system because it'll show us a lock on our end. It appears you have two emails on your account. Can you confirm with me which one you would like to use, and I'll remove the other one. Maybe this will help solve the issue. I got nothing back. That was a text message to her.
Were there other attempts to reset the password?
Yes, and it shows that there's no, like, she would have to accept that and set up a password on her end because it's completely secure. And she's stating that she's unable to do that.
If the tenant is unable to set up a portal access, are there alternative ways for the tenant to pay besides through the portal?
We have a cash pay option where she can get a cash pay card that is affiliated with her account and take the monies to Walmart. And it goes immediately on their account.
And how would she go about getting a cash pay?
I could email her one, but again, I don't have, I've never been a response of an email since she sent the one stating she was going to be late.
Now, you provided me a copy of a demand for possession and a lease in connection with this case, correct?
Correct.
And were those the documents that we attached to the complaint?
Yes.
And were those true and accurate copies of those documents?
Yes.
Were they kept in the ordinary course of business?
Yes.
Your Honor, I'd move admission of the demand for possession and the lease as well at this time.
Any objection to those documents being admitted, Ms. Lee?
No.
Those are the same or that are already in the file that were filed?
Correct.
Okay, they're admitted.
Thank you. No further questions.
Did you have any questions for this witness, Ms. Lee?
I would rather not, Your Honor.
Okay. When was, ma'am, I do have one question. Can you give me the date that you said you received the last email from Ms. Leak again?
Last
Or last communication?
Last email I received, well, there was a text on 6/27. And I was trying to call her. She said she wasn't getting any phone calls. I said, I'm calling the number that we're texting on. That was 6/27 at 1:54 p.m. She had texted me saying that she felt I was aggressive. I texted her at 1:56 and told her all of your calls, texts, and emails are documented on our end as well. And I apologize if she felt I had been aggressive. That was not my intention. That's the last correspondence I've had with her.
On 6/27?
Correct.
Okay. May this witness be excused?
Yes, Your Honor.
Thank you, Ms. Berry. You may be excused.
Your Honor, if I may approach, I'll give the court the key.
Thank you. And do you have any other witnesses?
I'll rest at this time. Thank you.
Thank you. Ms. Leak, did you want to give testimony today?
Yes, ma'am. So
wait, first, let me wait a minute. Raise your right hand. Solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, you can proceed to, you can put your hand down. You can tell me what you believe is your lawful reason why you have not paid your rent.
Okay, so first of all, I have an escrow. I've had an escrow apply for $11.39 of 8. I have $9,185 in escrow right now. And I told them that I would give them, here you go, this is what I owe. That's 1139 times 8. They want me to pay late fees and court fees when at the end of the day, I wasn't paying because, and even now, right now, Your Honor, I still can't get on the portal to this day. And I didn't know anything about a cash money payment, whatever it is that she was talking about. That's new. So I tell them, like, I give you this money now. You can have this. It's definitely owed. That's why it's been in escrow. They tell me, no, you need to pay the court fees and we'll waive whatever it is that our attorney said.
Why did you not respond after their last email or text message communication?
I've reached out to every message or email. For one, let me say this. I thought that I was emailing the Josh dude, which is the dude that originally, like, I signed my lease with. Come to find out, he wasn't working there anymore. And I didn't even know that my emails, that they weren't, like, getting my emails. She wasn't replying to them, meaning she, Kathy. So I didn't know that he wasn't there. So I was talking to nobody, realistically. I reached out to them October, telling them, like, wow, okay, at this point, I'm confused with your apartment complex. Like, do y'all not want to get paid? I can't get on the portal. This isn't because they're a slumlord or because I'm not able to pay my rent. This is me not being able to get on with their access of paying rent. Like, real, Your Honor, right? Then this is just transparency. I could have took my $9,000 and moved out and been on my way, realistically, and would have had to deal with whatever the consequences or however that would have went. But here I am. I'm not running. I definitely do owe rent, which is why I have an escrow. But I'm not paying for late fees and court fees and all, like, and we shouldn't even be here. It would have been as simple as them getting me into the portal, which, by the way, I still can't get in.
Okay. I have a question about this document, because it's not very clear to me. And you can answer from there because you're still under oath. My question is, where can I see where the last, well, if she reached out to you, like she said in October, would it be on here?
Those little on the side, Miss Your Honor, is a phone, and it'll show that's a text or a phone call. And then she's sent monthly reminders as well to her text. That's sent out by the system, sends that out automatically. So that's what you're seeing a lot of in the end. There's no correspondence back and forth with her and I since the June, like I said.
Okay, Ms. Lee, who were you contacting? Because I don't see anything on this transaction history that reflects you contacting the office.
Whatever the Josh dude was, the Lansing 517 or whatever it was, that's the email address.
You said, who's Josh?
I guess he used to work there. He was in the office when I first moved in, but he doesn't work there anymore, which I didn't know until the new maintenance dude had told me that a few months back.
So there used to be a Josh that you were communicating with, or did you used to communicate with Miss Berry?
No, I've never spoken to her at all outside of when I got my key. And I take that back because she came across my and she was being rude, and I had to tell her, like, you're being rude. So I haven't spoken to her at all since then.
What do you mean rude? You mean like she was talking aggressively, like you're
Correct.
doing in court today?
Oh, I'm sorry.
Thank you. Okay, so you did communicate with her previously? I see her name on your lease agreement, so I'm trying to find out where the Josh comes in and how you communicated with him. Did you text him, email him, or call him?
Email. He's the one that got me, like, you know, my lease. I talked to him when I went and synced the place. Like, I was communicating with him up until.
And you emailed him and said you couldn't pay your rent on the portal?
Yes.
Okay. Do you have those emails? I want to see them, and I also want to see proof of your escrow.
Is there somewhere that I'm supposed to send it, upload it? Like, how does that work?
Yeah, you seen it with yourself at court, where we all are.
Ooh, Judge Simmons.
That's how that works. That's why I order these in person, because you gotta give me evidence.
I was on your thing this morning. They told me to come back at 2. I don't know how I didn't. I don't know how that happened.
I don't know why you were here this morning. The note here from January 10th said you were always supposed to be here at 2. So I don't know why you came this morning.
I don't either. I thought I was supposed to be there at 8. I was excited to be there.
Okay, maybe you got confused by January 10th. I don't know what it was, but you got to appear in person because I can't see your evidence through the screen. So I'm going to adjourn this and continue this. You need to bring me proof that you were communicating, or at least you thought you were communicating with someone named Josh that worked at this company, and then that you have escrowed the past due amount rent in full.
Absolutely.
Have a new date.
January 31st at 2:45.
January 31st at 2:45 in person with your exhibits, okay? Not on your phone.
You said the 31st?
January 31st.
Okay.
Do you have any questions?
No, ma'am.
Okay, any additional matters on this file today?
Nothing, thank you.
Okay, you're all set, ma'am. We'll see you on the 31st in person.
All righty. Thank you.
You're welcome.
Thank you.
No, probably, you had one more?
I've got a couple more. I need to talk to them. So I'm going on those as quick as I can.
And Mr. Visconti, I don't see Tyrone Kelly.
I know that consent judgment was worked out with Mr. Kelly and.
And he signed it. Maybe, I think he must have misunderstood here. It looks like he signed his advice of rights on the 9th, which was yesterday, but he did not appear, so we're gonna have to reset this.
Going to reset it?
Yes.
Okay. Got that date now, or?
January 31st at 2:45. January 31st at 2:45.
Very much. That concludes my matters.
Thank you. Have a good one.
You too. Thank you.
I want to talk to him on a CD. Do you want me to put the CD on the record now?
Is this the CD?
Yeah.
Oh, we can do it now.
Okay.
Who is this one?
This is gonna be Kayla.
Okay, on the record. In the matter of Todd Doward versus Michaela Hoffman, file number, thank you. 23-02970 LTE, council appearance.
Good afternoon, Your Honor. Norman Whitty appearing on behalf of the plaintiff.
Okay, and your name, ma'am?
Michaela Hoffman.
Okay, Ms. Hoffman, today's the date that was set for hearing. I do have a consent order for conditional dismissal. It states that you want to enter an agreement whereby the case will be dismissed today upon the condition that you will pay the past due rent in the amount of $329.52 due through the time period of January 31st, 2024, plus court costs, $213.64, for a total of $543.16. It also states that you will pay $300 no later than January 11th and $243.16 by January 22nd. Is that accurate?
Yes.
Okay, and that's your signature there?
Yes, it is.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury? Yes. Okay, you have a couple of rights, ma'am, that you would need to waive if you want to enter into a conditional dismissal. Did you understand that you had the right to be represented by an attorney today? Okay, and are you waiving your right to counsel today? You also have the right to proceed to a jury trial in this matter. Did you want to waive your jury trial?
Yes.
Anybody threatening you to get you to waive those rights?
No.
Do you understand that partial performance and partial payment will not satisfy this dismissal? So that means the case will be dismissed today and it'll stay dismissed so long as you pay the amounts owed here on the dates that you say you're gonna pay them. You understand that?
Yes.
If you don't do that, or if you pay less than that amount, or if you pay that amount but late or later than the dates that you said you would pay them, the plaintiff can request to have judgment entered against you immediately, and then the eviction will proceed against you without you getting any notice of that. Do you understand that?
Yes.
Do you have any questions?
No, ma'am.
You have 3 business days from today's date. If once you leave here, you realize you misunderstood the rights that you just waived, you can return and request to have this set aside and we'll set it for a hearing, okay?
Okay.
We'll get you a copy of your notice and then you'll be all set. Thank you.
Thank you, Your Honor.
Okay, she responded. She must be on the bench. Okay, on the record, in the matter of Cherry Hill Improvements LLC versus Caitlin Anderson and Edward Cruz. File number is 23-03119 LT, counsel appearance.
Good afternoon, Your Honor. Norman Whittier, appearing on behalf of the plaintiff.
And what's your name, ma'am?
Caitlin Anderson.
What's your name, sir?
Edward Cruz.
Okay, today was the date and the time that was set for hearing for non-payment of rent. My understanding is the parties have not come to a resolution yet.
Not, yeah, I think we're close. I think we agree on the numbers.
Yeah.
But we have not gotten to the point where there's an actual consent.
Okay, so you're looking to do a consent judgment?
That would be my preference. Your
Okay, how much time do you need?
Honor. Your Honor, if you want, I can put the numbers on the record. If they don't disagree, we can enter it now.
Okay,
I'll just put those numbers on the record. There's rent to retain, $6,430. Court costs of $238.38. Total possession amount of $6,668.38. Money damages prorated through today's date are $5620.48. Court costs again at $238.38 for a total of $5858.86.
and you're disputing those numbers or you agree with them?
I agree with those, yeah.
Okay. You can execute that document.
You'll have to write up your questions. They don't really have a lot of things.
Okay, so I have a consent judgment. It's, you want to enter judgment by consent indicating that you agree that the past due rent to retain possession of the property of 314 East Hillsdale Street is $6,430 plus court costs of $238.38 for a total of $6,668.38 of an amount to retain possession. There's a money judgment amount, again, $5,620.48 plus $283.38 for a total amount of $5,005. That's not the amount that I just wrote down. I have $5,620.38.
I'm sorry if I misspoke.
Oh, okay. Is it okay? Is it 38 or 48? It's 48. The cents on the damages.
If that's what it says.
Okay. You had something that you objected to?
It says to retain the property. We wanted to terminate the lease.
You want to vacate, is what you're
Yeah,
saying?
yeah, just making sure that's.
Okay. Okay, so that's to retain possession, you would need to pay the total amount due of $6,668.38 or vacate
Okay,
by
thank you.
January 22nd, 2024.
I appreciate that.
Okay, and then there's a money judgment that's due. It says again, $5,620.38 plus court costs, again, $238.38 for a grand total of money damages, $5,858.86. Okay, and I see a signature here. Did you both sign here?
Yeah.
Okay, so you have the right to be represented by an attorney in today's proceeding and during eviction proceedings. You were advised of that right at the time of your pre-trial in December. You've appeared without an attorney today, is that correct?
Yeah.
You're waiving your right to an attorney?
Would we still be able to get one? Because it was my understanding that they said they wouldn't. During. the
Legal
pre-
services may not have been able, but you had an adjournment so that you could secure an attorney. That's why we had a
Okay,
pre-trial to advise you of that right. Okay, so are you waiving your right to an attorney today?
yes.
Okay, what about you, ma'am?
Yes.
Okay, you also have the right to a jury trial and you have the right to demand the jury trial. We did not receive a jury demand in this matter. Are you waiving your right to trial?
Yes, Your Honor.
Okay. Anybody forcing you to waive these rights and enter into consent judgment?
No.
No.
Any promises being made if you enter into consent judgment?
No.
You have 3 business days from today's date. If once you leave here, you realize that you misunderstood the rights that you just waived, you can return to the court and request to have this judgment set aside. We'll set it for a hearing, okay?
Okay.
Do you have any questions?
Nope.
We'll get you a copy of your notice or your consent judgment, and then you'll be all set, okay? Thank you. Off the record.
Thank you. Appreciate your time today.
No problem.